We are now going to move on to our next topic, which is professional liability cases, and specifically on evidence and standard of care issues in dealing with the professional liability claims. Elizabeth Boker will answer the eternal question, is it ever okay to nick a ureter? Liz?
Thank you, Frank, and good morning, everybody. I'm a little bit daunted at being tasked with answering an eternal question, but let's get to it. First of all, thank you, everyone, for welcoming me and welcoming my colleagues into your home and offices this morning. I'm sorry we can't connect in person, but one day we will be able to, and in the meantime, I'm really glad that we can connect this way. So today we'll be talking about circumstantial evidence and the standard of care, and specifically two recent cases from the Ontario Court of Appeal. Before we get into those two cases, I want to start off by giving you a bit of a roadmap as to what we'll be talking about today. So first of all, we're going to do a brief recap, just reviewing what is standard of care, how does that fit into the grand picture of negligence, and what is circumstantial evidence. We will then turn to the two cases that we'll be talking about, the Armstrong case and the Condo and Shanks Plumbing case. And lastly, I'll talk a little bit about those implications. And of course, if you have questions, please feel free to let us know what those questions are, and we'll leave time to deal with those at the end. So first of all, a little bit of recap. Standard of care. As we all know, it's part of the negligence analysis. First of all, a plaintiff, to prove his or her case, has to prove that the defendant owed the plaintiff a duty of care. Standard of care is the second part of the negligence analysis, and the plaintiff has to prove that the defendant's conduct, so whatever the defendant did or didn't do, that conduct breached the standard of care. And then thirdly, the plaintiff has to show that the damage that was caused by the defendant's acts or omissions caused damages to the plaintiffs. So when we're looking at the standard of care, and today we'll be focusing in particular on professional liability cases, the conduct of the defendant that we're looking at is compared to the conduct of a reasonably prudent and diligent fellow professional acting under the same circumstances. And by that, what we mean is we're looking at somebody who's operating in more or less the same environment in the same time and space. For example, the standard of care of a physician practicing for Doctors Without Borders, perhaps in a war environment, in a tent, is not going to be the same standard of care that we would look to in a physician practicing in a downtown teaching hospital. The standard is not a standard of perfection. You don't have to be perfect, but you have to do what a reasonable fellow professional would do in the same circumstances. Now, in terms of when a trier of fact should be determining whether the standard of care was breached, generally you're supposed to do that analysis before looking at the causation part of the negligence test. So before getting to the but for this breach of the standard of care where the damage had been caused, you're already supposed to have determined, has this standard of care been breached? And what we'll be discussing a little bit further today is what role does circumstantial evidence of harm play in the analysis? So let's just have a little moment here to review what circumstantial evidence is. It's certainly a phrase that's tossed around a lot in TV shows about law. What it is evidence that permits you to make a conclusion that indirectly establishes that something did or did not take place. And I found this quote from Thoreau. Some circumstantial evidence is very strong, as when you find a trout in the milk. And there's the trout in the milk. And this puzzled me a little bit, and I did a bit of research. And you know, it's a rainy Wednesday morning. We've got some time. So let's just chat about where this came from. So in 1850, Thoreau was writing in his journal. He was writing about a little brook in a marsh someplace, I guess, in the United States. And he suddenly injected this sentence: some circumstantial evidence is very strong, as when you find a trout in the milk. Thorough scholars speculate that he was thinking of unscrupulous dairymen who added water to their milk to increase its volume. So this would affirm Thoreau's meaning. If there's a trout swimming in your milk, it's pretty likely that there's water in your milk as well. I mean, I know for me, if I go down to my refrigerator and I see a trout in the milk, it's pretty strong circumstantial evidence that my kids have been playing around and I should take immediate action. All right, so we remember circumstantial evidence, and now we've refreshed our memories as to what standard of care is. So let's turn to the first of our cases that we'll be discussing today. This is a recent Ontario Court of Appeal decision, Armstrong and the Royal Vic Hospital. Actually, by the time it got to trial, the action had been dismissed against everybody except the one doctor who did the surgery, Dr. Ward. The surgery at issue was a colectomy. After the surgery, the plaintiff, Miss Armstrong, suffered a severe left flank pain, and after some examinations, it was discovered that there was a blockage in the left ureter, which is the tube that connects the kidney to the bladder. And unfortunately, Ms. Armstrong had to have her left kidney removed. So looking back at the original surgery, the colectomy, did something happen during that original surgery performed by Dr. Ward? Dr. Ward used something called a ligature, which is an instrument that first of all cuts and then fuses tissue, and it uses an electric current to do so. And because it's using electricity, you can get a thermal injury, a burn, if you get within about 2 millimeters of any other tissues. In case you're wondering, and I'm sure you were, this is what a ligature looks like. So basically a long set of scissors, but there is an electric current running through it. So the issue at trial then was, did the surgeon meet the standard of care by following the normal steps of this colectomy? Or was the existence of injury, the fact that we know that the ureter was damaged, was that evidence that the standard of care must have been breached? What was the evidence at trial? It was accepted by both sides and the experts that the standard of care of a surgeon practicing in these types of circumstances required the surgeon to first of all identify, take steps to protect, and then avoid the ureter during surgery. I should point out that this is all laparoscopic surgery, so it's being done by camera. The experts all agreed that you need to stay 1 to 2 millimeters away from the ureter to avoid any damage. And in fact, the surgeon testified at trial, I did take steps to identify and protect the ureter. He admitted on cross-examination that from time to time, the ureter wasn't always in the view of the laparoscopic camera. So the trial judge has to decide what to do with all of this. And the trial judge said, well, I know what the injury is. The injury is that the ureter has been damaged. And that fact, that circumstantial evidence of the ureter being damaged, means that the surgeon must have brought the ligature within 1 to 2 millimeters from the ureter, which then in turn led to scar tissue and blockage. Therefore, I can conclude that the surgeon must have breached the standard of care. And the trial judge reached that conclusion even though he found that the surgeon had taken the appropriate steps to identify and protect the ureter. So perhaps not surprisingly, this went to the Ontario Court of Appeal last year, and it was a split decision which overturned the trial judge's reasoning and decision. And we'll talk about that in a little more detail. As an overview, the majority held that you can't measure whether a surgeon met the standard of care or not based on the surgeon's goal during the surgery. Rather, you have to look at what the surgeon did to achieve that goal. So in this case, I think the goal is not to harm the plaintiff, not to cause a blockage to the kidney. So what steps did the surgeon take to achieve that goal? And the Ontario Court of Appeal reminded us that you look at the behavior that a reasonably prudent surgeon in those circumstances would take. You don't measure a standard of care based on whether the surgeon actually achieved the results, because that would be getting too close to requiring a standard of perfection, and we know that is not the rule in negligence. The majority of the Court of Appeal said the trial judge should have restricted his analysis to whether the surgeon followed the appropriate steps of a colectomy. So, to recall, the trial judge had found that a prudent surgeon should first of all identify where the ureter is, secondly, take steps to protect it, and third, avoid getting too close to it. And the majority said once the trial judge found that the surgeon did all three of those measures to achieve the goal, then the analysis should have ended right then and there. The trial judge shouldn't have gone on to look at the actual injury that was suffered. And there's a lot of talk in this decision about measures and goals. So the measures in this case were the measures or the steps that the surgeon took to keep the ligature a safe distance away. The goal of the surgery was to avoid getting too close to the ureter. And the majority said you just can't judge the standard of care based on the goal, because that would amount to strict or absolute liability. Again, that's requiring a standard of perfection, and that's just not the standards by which we measure professional negligence. And the majority also said you can't place too much weight on whether the surgeon achieved the desired result, because that conflates the standard of care with the causation analysis. So taking a step back, the majority says that, we don't want to go so far as to say you can never consider the results of the surgery, or in this case, you could never consider the actual injury. Sometimes you may consider the goals and the results where a negligent act is the only possible explanation for why a result is not achieved. And I'll give you some examples of that in just a moment. What the trial judge should have done is rule out possible non-negligent causes of the injury before assessing the standard of care, and the trial judge didn't do that here. And so the majority of the Court of Appeal said, again, you don't get to the causation analysis until you've already gone through step 2 of the negligence analysis, which is what is the standard of care and has that been breached. So examples of when there really are no non-negligent causes of the injury might be, for example, if you cut off the wrong leg during surgery. There's no non-negligent explanation for that. Or if you leave a surgical tool or a sponge inside the patient. The only explanation of that circumstantial evidence is that there must have been negligence. And in that case, the Court of Appeal said, you can define the standard of care as a goal. It doesn't really matter. It's just so obvious that the circumstantial evidence of injury is proof that the standard of care is breached. But the Court of Appeal seems to be signaling that those cases will be few and far between. So in dissent, Justice Van Rensburg gave quite a lengthy and detailed dissent, and she said a trial judge should not have to consider all possible non-negligent causes of the injury, particularly where none of the parties are advancing that kind of argument. And just to let you know, some of the arguments that were raised in oral argument at the Court of Appeal were, what if, for example, there was an earthquake during surgery, and maybe that was the reason that the surgeon got too close to the ureter with the ligature. I mean, that would be a non-negligent cause of the earthquake. But the defense wasn't advancing the argument that an earthquake happened during the surgery. Presumably, if an earthquake had happened, then the defense would have advanced that argument. But no one was saying that. And so Justice Van Rensburg is saying, it shouldn't be up to the trial judge to have to consider all these other possible non-negligent causes where no one's putting forward the argument that a non-negligent cause of the damage to the ureter it was what caused the damage. And in this case, there was no evidence, there was no expert that said that a surgeon who was taking appropriate care could not have stayed at least 2 millimeters away from the ureter. And in fact, the surgeon didn't even testify that I was trying to stay away, but the anatomical structure in this case was so difficult that I couldn't do it. There was no evidence like that. So while Justice Van Rensburg agreed with the majority that typically you should make a decision on whether the standard of care was breached before you address causation, she said in this particular case, the trial judge was entitled and in fact required to consider the circumstantial evidence of harm, so the blockage of the ureter, and to make findings about what happened before he could do the standard of care analysis. So this case has been granted leave to appeal to the Supreme Court of Canada, and it is in the process of working its way through the Supreme Court. So the applicant has now actually, or the appellant has delivered her arguments, and I assume in the next couple of months, the defendant, Dr. Ward, will submit his arguments. Two interveners have sought leave to intervene. That's HUROC and also the Ontario Trial Lawyers Association. So we're waiting to hear whether the Supreme Court of Canada will hear arguments from those interveners, because there are some interesting and important facts being raised there. As you probably know, to get to the Supreme Court of Canada, you have to show that there's a matter of public importance. And the way that, public and national importance, and the way that the plaintiff phrased her argument was that it's very important as a matter of public and national importance that we get clarity on what is the standard of care for professional liability in these types of cases. And I've looked at the way that the plaintiff posited these issues of national and public importance at the Supreme Court. And the questions that will probably be dealt with are, what is the standard of care for professional negligence in Canada? Where should courts draw the line on the acceptable margin for error? May causation be used as circumstantial evidence to inform the standard of care? Is it an error of law to use the outcomes or the goals as the standard of care? Must a trier of fact consider and rule out other non-negligent causes of injury? Where's the burden of proof? So the issues that I think the Supreme Court of Canada will be grappling with are, is it enough for doctors to simply understand these are the steps that I have to take in order to avoid injury, and I intended to take those steps? Or is a surgeon required to actually do all of those steps? Can you use the outcome of a medical procedure as evidence that there was circumstantial evidence that harm actually occurred, and therefore there must have been a breach of the standard of care? And in terms of the implications of this case, one implication is if the only necessary evidence that a defendant has to put forward to discharge his duty of care is an intention to meet the standard of care. So my goal was to meet the standard of care, and these are the steps I took. If all you have to do is say, I intended to meet the standard of care, and I did take these steps, then I think the implication is that most cases of professional negligence will fail, because it's going to be a very rare case where a plaintiff can demonstrate that the defendant missed all of the steps or was reckless or intentionally caused damage. There's some other issues going up to the Supreme Court as well in terms of the standard of review of a trial judge. But again, going back to the focus of our discussion today, I think the way that a plaintiff put it in her materials to the Supreme Court is fairly helpful. The implication of this precedent-setting, or put another way, precedent-altering decision, is that the burden of proof will always be placed upon the plaintiff and her experts to advance and rule out any number of other potential causes of injury, whether raised by the defense or not. Anyway, all things to think about as this winds its way up to the Supreme Court of Canada. If you're interested, you can go on the Supreme Court website and you'll be able to see the written materials submitted, and I anticipate it will probably be argued within the next year. So we will keep watching that, and I hope you will as well.
Liz, there's a question on the facts of the case that's come up, and I just want to interrupt your presentation to ask that. The question is whether there was a discussion in the case about whether the surgeon should have ensured that the camera was always on the ureter, that the negligence was in not having the camera always have the ureter in view.
I can't tell that from the decision itself, what I've read. I mean, certainly the physician seems to have admitted that you need to use a camera in order to figure out how close you are to any organ. And he, that was one of the steps or the means that he took to achieve his goal, was using the camera. I would suspect that it seemed to be accepted that you're dealing with a small physical environment, and that it may be that the camera just can't see everything all of the time. But with respect to that specific question, I'm not sure that I can tell from the Court of Appeal decision whether that particular piece of evidence was raised. So I'm going to turn to the second part of my presentation now, which still deals with circumstantial evidence. If you've been sitting for a long time and want to take a break, now is a good moment just to move around a little bit. I won't be offended because I know you can stand up and I won't know. So let's move on to the second part of my presentation. So recapping. Are experts always necessary when we're dealing with professional liability claims? Usually, yes, they are. You need an expert to tell you if the standard of care has been breached. There are a few cases where you don't need an expert. If we're dealing with a really non-technical matter, which is within the knowledge and experience of an ordinary person. So I, for example, could not opine on the standard of care of a surgeon performing a colectomy, but there may be issues where it's just not technical and a judge would be expected to have knowledge of that. The other example where you might not need an expert is if it's so obvious that whatever the professional did or didn't do would have breached a standard of care, then you may not need an expert. You may not know exactly where the parameters of that standard of care are, but wherever the parameters are, it's obvious that there was a breach. And so this was affirmed fairly recently by the Court of Appeal in the Central Auto Parts case a few years ago, which pointed out that expert opinions are not necessary where the impugned actions are so egregious that it's obvious the defendant's conduct has fallen short of the standard of care, even if you don't know what the parameters of the standard of care are. So the case that we're going to look at next is a decision from 2020, so earlier this year. It's Metro Toronto Condo Corp. Versus Shanks Plumbing. The facts: the plaintiff, the Condo Corp., owned a historic building, I think around Bayview and Lawrence in Toronto. And there were renovations, a plumber was doing some work, and a fire happened. The work that the plumber was doing required some repair with a blowtorch. And the fire started very close to where the plaintiff was working. And I know you're all interested, so I believe that this is a photo of the actual fire that took place that morning. And as you can see, it is quite a conflagration and, probably quite a lot of damage there. I'm not sure exactly where the plaintiff or the plumber was working and all that, but somewhere in that beautiful historic mansion. So what was the evidence at trial? The plaintiff actually chose, for whatever reason, not to call any expert evidence as to what the standard of care was of a plumber working in these circumstances. The plaintiff instead relied on the National Fire Code and the Fire Code regulation. However, in oral submissions at the end of trial, the plaintiff's lawyer said, look, the use of a blowtorch in these circumstances was so egregious that we can obviously infer a breach of the standard of care. The plaintiff did call two causation experts who said this fire was caused because the blowtorch that the plumber was using contacted combustibles in the area. Now, the defense, the plumber, didn't call any expert on the standard of care either, and didn't call any expert evidence on causation. The plumber testified. And like the surgeon, Dr. Ward, in the Armstrong case that we just looked at, the plumber went through all the steps that he took, or the means that he took, to avoid injury. So he said, first of all, I inspected the work area. I didn't see any flammable materials. There'd been recent flooding, so there was a lot of moisture around. Materials were wet and damp. I pointed the blowtorch away from any wood. It's true I didn't place a fire-resistant blanket down, but that's because the ceiling was leaking and everything was wet. And then I remained on site for 30 minutes to fulfill my obligations under the fire watch. So these are all the steps I took to achieve my goal of not burning down the building. He didn't say it that way, those are my words. The trial judge thought that the plumber was credible and believed and found that the plumber had taken all of those steps to avoid a fire. The trial judge also held that the plaintiff had failed to establish a breach of the standard of care, and also that the plaintiff failed to establish causation. The trial judge also said, look, there's just no evidence before me that these fire codes are part of the standard of care applicable to plumbers. The trial judge was also quite critical of the fact that that no expert evidence was called about how a plumber should have undertaken this role. And he said, look, soldering is technical work. It's not something that's within the ordinary knowledge of a trial judge like myself. It's technical. It requires expert evidence to assist the trier of fact with what the standard of care is, how this should be properly done. And there's just nothing so obviously egregious about what the plumber did here that allows me to get past the usual requirement that you require expert evidence on whether this particular professional met the standard of care. Now, the causation issue was somewhat problematic, said the trial judge, because the plumber was the only person working in the area with a blowtorch, and we know the building burned down. So you would think that circumstantial evidence might allow you to infer that whatever the plumber did or didn't do, the fire was caused by the plumber, and he must have breached the standard of care somehow because we know the building burned down. And there was no other evidence as to what could have caused the fire. There was no other non-negligent activity that might have caused the fire. Like, for example, no one was putting forward evidence of arson or of a lightning strike in the area or anything like that. On the flip side, there was no evidence that anything the plumber did caused the fire. So the trial judge found in favor of the plumber and dismissed the action. And the Condo Corp plaintiff took this to the Ontario Court of Appeal. And the Condo Corp argued, look, there was a fire. That is, the trial judge should have drawn an inference that the plumber breached the standard of care based on the circumstantial evidence of the fire. There was no alternative explanation. The fire occurred right after or shortly after the plumber finished his blowtorch activities. That's circumstantial evidence. We should be allowed to draw the inference that there was a breach of the standard of care. The Ontario Court of Appeal in this particular instance was unanimous, and it dismissed the Condo Corporation's appeal. And it said, yes, it's true, sometimes you can draw inferences about a breach of the standard of care based on circumstantial evidence. However, it's open to the trial judge to refuse to draw that inference, and this was one such case. The trial judge was entitled to find that, first of all, the plaintiff's failure to call any expert evidence on standard of care or causation was fatal to the plaintiff's case. So that was open to the trial judge to make that finding. And it was also open to the trial judge to find that expert evidence was required because the plumber's use of the blowtorch was not obviously egregious. Soldering is technical work, and therefore, if you're going to argue that there was a breach of the standard of care, you need expert evidence to advise you what the standard of care is. And this is the case even though the defendant provided no possible alternative explanation as to how the fire was caused. And that's a little bit different, if you recall, from the Armstrong case that we just looked at, where the inference is that maybe defendants should be putting forward other evidence as to what other possible causes there could be for the injury that we know happened. In any event, in this plumbing case, the causation and circumstantial evidence did not prove a breach of the standard of care, and the Ontario Court of Appeal seemed quite unanimous and happy to confirm the trial judge's reasoning there. So, bringing this all together, what does it mean for us? What are the implications of these decisions? First of all, I'd say for plaintiffs, if you are pursuing a case against a defendant, and in particular a professional liability type of claim, circumstantial evidence is probably going to factor in somehow, but you need to be cautious about building your whole case on that. It may not be enough. The fact that there was an injury, and we know there was an injury, may not be enough to show that there was a breach of the standard of care. The plaintiff still has the burden of proving that the defendant failed to meet the standard of care, and particularly in professional liability cases, plaintiffs really should be putting forward expert opinion evidence as to what that standard of care is, unless you fall into one of those rare categories where it's just so obvious or non-technical that an expert opinion is not required. And it looks like courts may only consider circumstantial evidence as evidence of the breach of standard of care in exceptional circumstances. And now I'm happy to take questions, and I hope you've had your fill of circumstantial evidence this morning.
So Liz, we do have a few questions that were asked. The first one was when you talked about the different standards of care depending on the circumstances that a professional is acting in, and you gave the example of a emergency aid station in a war zone, and that might have a different standard than in a big city hospital. So the question that came in was about experts in that scenario. If you have a situation, and the example was a generalist lawyer working in a small town, and he is alleged to have committed a malpractice in, say, a civil litigation area, should your expert be a civil litigation specialist from Toronto, or should you find somebody who does general law in small towns in Ontario?
Thank you for that question. I have always followed the view that you should try to find somebody who's, if in a professional liability situation, you should try to find a peer. So somebody who is practicing in a similar environment, in similar circumstances, and had experience in a similar time frame. So in your example, Frank, when you're talking about a generalist who's practicing in a small town, my recommendation is that an expert in that case should be somebody who is maybe a generalist in another small town. You don't judge by comparing somebody who's a generalist with someone who's a specialist. Indeed, the standard of care for specialists is more elevated. If you are proclaiming yourself to be a specialist to the world, then you're going to be held to the standard of care of other people who are specialists in that field. But like I say, when I'm looking for experts, I'm trying to match as closely as possible the idea that you're in similar circumstances in a similar time frame. The reason for the similar time frame, of course, is that you don't want to judge somebody based on hindsight or development in science that's taken place since whatever the impugned act was. So, if we're talking about a surgery that took place in 2010, we want somebody to opine on what was the standard of care in 2010, not what is it in 2020 with perhaps more recent developments in science and policies and procedures. So I try to match like with like.
Thank you. The next question is with respect to, again, to the Armstrong case, the first one you spoke about. And the question is, how do the principles in that case apply to other professions? In other words, in that case, it was a doctor trying to achieve a goal and a purpose, and one of the steps went wrong. How would that apply to other professions and other professional liability scenarios?
I mean, many of these medical or these professional liability cases come to us from the medical malpractice world, but it would apply to any other professional liability case. For example, we just looked at the case of a plumber who is a professional, and if we look at what happened in that case, the plumber did testify about the means that he took to achieve his goal. And the trial judge seems to have accepted that testimony. So certainly that same analysis can apply in the case of plumbers, and I would expect that it applies to any other professional, real estate appraisers, lawyers, nurses, teachers, accountants. So I think it will apply broadly, which is why it's important for us all to follow what happens at the Supreme Court to see what guidance we get about how you can use circumstantial evidence of harm as an indication that the standard of care may have been breached.
Okay, thanks, Liz. And another comment came in with somebody with knowledge of this case that the plumber was in the rec room.
In the rec room. So I apologize, my photo did not show the rec room itself, but I'm sure it was in the photo somewhere.
And that the fire happened actually at the corner of Bayview and Lawrence near Glendon College.
All right.
Now, the next question is as follows, and I'll read it because it's long. In the fire case, did you think that the trial judge refused to draw the obvious inference on breach of the standard of care based upon what he realized was his own knowledge or lack of knowledge of the plumbing process? Thus, he decided he wanted or needed the evidence and was not provided with it. Should the defense always assume the worst in terms of a trier of fact's knowledge of such things as trades or other experts?
So starting with the last part of that question, should the defense assume the worst? I mean, I think you should go prepared. Whether that means assuming the worst, but I think you should go prepared that a trier of fact may want to substitute his or her knowledge as to how some matters may be accomplished. It may be that the judge plays around with blowtorches in his spare time and therefore has some knowledge of how that works. It's more unlikely that the judge is going to be doing colectomies and have any knowledge of that. But I think to forestall that concern, the appropriate thing to do would be to come armed with an expert so that whatever a judge may think about the appropriate standard of care because of his or her own background or beliefs, you can put forward more positive expert opinion testimony as to, this is the actual standard of care, irrespective of what a judge may believe. To answer the first part of the question, do I think that the judge made the decision here based on his or her own beliefs? Hard to say. I mean, we have the Court of Appeal decision, so I could not find the oral trial decision published. So I don't know how much the trial judge was actually importing, his personal background or experience with plumbing. Certainly, the trial judge, I think, was persuaded, as far as I can understand it, from the fact that the plumber was credible. And so when the plumber testified about the 6 or 7 steps that he took to avoid causing a fire, the judge seems to be quite persuaded by that.
Okay, Liz. I'd like to thank a lot of you who are not just writing in on our questions in the question box in front of you, but have also been texting and emailing me about trouts and glasses of water and milk. The gentleman who wrote in about circumcision evidence. So that's been very helpful as well, but we won't address these. It sounds like people are getting a bit giddy out there, so I think it's a good time to pause for a break. And we'll be back at 10:40, 20 to 11, and see you then. Thank you.